Welcome everybody. It's great to have you here with us. My name is Ido Rosenzweig. I'm the chairman of ALMA, the Association for the Promotion of International Humanitarian Law, Israeli-based NGO, which is aimed for the promotion of the discussion, understanding, and promotion of international humanitarian law, the laws of armed conflict. And I welcome you to another session of our IHL book launch series. We've started that series about 2 years ago. We've had several very, very interesting events, and we're finally back. We're actually, as we said before, many times again, we're actually taking advantage of the new reality, the new COVID reality, in order to host these events and give an opportunity to get exposed to new books and new publications related to international humanitarian law. I'm quite sure you've already understood that I'm basically stalling a little bit of time until more people join in. But what we're going to do today is I'm going to moderate the discussion. We're going to have a very, very interesting discussion on a new book that was published recently titled Lawmaking and Legitimacy in International Humanitarian Law. The book is edited by Heike Krieger and Jonas Püschmann, and we also, of course, both of them are here with us. And alongside that, we have author of 3 selected chapters from the book. And the format of the session tonight is going to be a short introduction of the book by Heike and Jonas, followed by presentation of the chapters by Jean-Marie, Hyeran, and Tim. All of them I will introduce very, very soon. And then after that, we will open the floor for some Q&A and comments from the audience. And yeah, and that's it. So I'm going to start with a short introduction of all the participants, all the speakers. So we won't have to do it later again, one by one, and we'll be focused on the actual presentation. So I'm going to start with Heike Krieger. Heike Krieger holds the chair for international public law at the Freie Universität in Berlin. She is co-chair of the Berlin Potsdam Research Group, the International Rule of Law Rise or Decline, and has been Max Planck Fellow at the Max Planck Institute for Comparative Public Law and International Law in Heidelberg between 2017 and 2021. Heike Krieger is co-editor of the Yearbook of International Humanitarian Law of TMC, Press and Springer, and member of the editorial board of the Journal of Conflict and Security Law at the Oxford University Press. Jonas Püschmann is a research fellow at Max Planck Institute for Comparative Public Law and International Law, and a doctoral candidate at the Freie University of Berlin. His research interests include international and regional human rights law, general international law, migration law, and international humanitarian law. After studying law at the University of Leipzig, he previously completed his legal clerkship, working among others for the office of the Federal President in Berlin and the permanent mission of the Federal Republic of Germany to the Office of the United Nations and to other international organizations in Vienna. Hyeran Joe is Associate Professor of Political Science at Texas A&M University in the United States. She is the author of Compliant Rebels Group in International Law. She has researched and published many pieces on the topic of international humanitarian law and non-state armed groups. Jean-Marie Henckaerts is head of the ICRC project to update commentaries to the Geneva Conventions of 1949 and the additional protocols of 1977. So far, that team has already published updated commentaries for the first, second, and third Geneva Conventions. and they are currently working on the updated commentary of the Fourth Geneva Convention. Prior to this, Jean-Marie was the head of the ICRC's project on customary international humanitarian law. He holds degrees of Doctorate of Judicial Sciences from the George Washington University of Law School, Master of Laws from the University of Georgia School of Law, and Bachelor of Laws from the University of Brussels. And last but of course not least, Timothy Meyer is Professor of Law and the Director of the International Legal Studies Program at Vanderbilt University Law School. He is an expert in public international law with specialties in international trade, investment, and environmental law. Professor Meyer has testified before the US Senate Committees on Foreign Relations and the Judiciary, and has served both as counsel and as an expert in cases raising international law and trade issues in the US courts, including litigation challenging the Trump administration's national security tariffs under Section 232 of the Trade Expansion Act. Professor Meyer entered the legal academy after practicing law for several years at the Office of the Legal Advisor at the US Department of State. He earned his BA and MA in history from Stanford University and his JD and PhD from the University of California, Berkeley. That was the short introduction aspect of the event, and without spending too much time on anymore, I give the floor to Heike, please.
Oh, okay, now my unmuting has worked. Okay, fine. Thank you so much for inviting us for this event, for hosting a book launch for this event. And it's really a privilege for us as editors to present this book published in November 21. We are really glad to be with you, and we are glad that we have with us 3 of our contributors to this edited volume on lawmaking and legitimacy in IHL. In the short presentation, I will give you an overview of the main ideas and reasons which have prompted this book, and Jonas will then share with you some of the book's key findings. So what's this book all about? Well, whether we look into the fighting in the Ukraine, into a cyber attack against the Ministry of Defense, into the ongoing conflict in Syria, or whether we want to engage with artificial intelligence and IHL, for assessing any of these developments, we need to know what the law is. But who has the authority to say what the law is, and even more important, to change and to adjust the law where change might become necessary? For the traditional international lawyer, the obvious first choice would be states. But although IHL is constantly challenged by such developments as the new war paradigm or technical development, no major multilateral treaties in IHL have been concluded since 1977, maybe with the exception of some treaties in the field of weapon law. And to some extent, states seem also reluctant to provide legal opinions on contentious issues. So the question arises, how can international humanitarian law develop at all? And what we see instead of state-led lawmaking processes are manifold delegated and informal processes, ranging from courts' decisions over manual and expert processes to non-binding declarations or maybe even statements of NGOs. There is a growing number of interpretative communities emanating from international organizations, national and international courts, semi and quasi-judicial bodies, expert groups, and even one may say non-armed groups when it comes to ceasefire agreements, for example. Thus, IHL seems to evolve and to be vibrant, irrespective of states' engagement, and despite concerns about its compliance pull in view of grave violations that we can also currently observe in this field. So does this reflect declining importance of states in international law or international humanitarian law, or do states even welcome this development? Or does this obstruct the ability to secure legally coherent outcomes and thereby contribute to ambiguities? After all, and eventually, IHL must be effective on the ground, and therefore a gap between the diverging interpretative communities could endanger the very functions of IHL, especially if states are not on board. The book approaches this ambiguous state by refocusing attention on lawmaking processes and the actors involved through the lens of legitimacy. Discourses, both in academia and in diplomatic practice, about the state of international humanitarian law often center around issues of effectiveness and compliance. If legitimacy concerns are at all addressed, such concerns are considered to be a symptom for the lack of effectiveness rather than its cause. And our book suggests to turn this upside down and to turn away from debates about compliance and effectiveness, but assess the state of international humanitarian law by refocusing on legitimacy. This approach is based on the work of Tom Frank. He argued that legality itself does not secure adherence, but adherence depends on legitimacy. Legitimacy can thereby be used to research normatively the compliance pull of legal norms. And against this backdrop, we have asked our authors the following questions and formulated, well, let's say 3 hypotheses. First, the increasing diversity of actors in the lawmaking process affects its legitimacy, but the way in which it affects the legitimacy is ambiguous. On the one hand, the diversity of actors may enhance IHL in terms of process and normative outcomes. In particular, NGOs are often seen to promote transparency and participation. After all voices are heard, or more voices are heard than merely state voices. Also, together with courts, they often push for improving the normative aspirations of IHL. Just think of Cassisi's role in the ICTY. On the other hand, the contributions of courts and NGOs are themselves subject to criticism. Think again of the ICTY and the example of its findings on belligerent reprisal. In that case, many international humanitarian lawyers simply claimed that the court got it all wrong. Likewise, NGOs faced the criticism that they often present the law in a biased way, not taking into account appropriately the balance between humanity on the one hand and military necessity on the other hand. Or take expert manuals. Are these processes legitimate in terms of participation and transparency? There is a concern that expert processes are not inclusive, but predominantly composed of Western military lawyers. Our second hypothesis was to assume that legal methodology is a decisive instrument in creating legitimate outcomes. So we encouraged our authors to reflect upon the question as to whether legal methodology can work to limit biases and one-sided interests. For example, is the way in which manuals derive at and present their results transparent, or are there hidden agendas if a certain manual is supported by NATO, for instance? And also, what is the role of such manuals in changing the law? Are there really just legal commentaries as we know them in many national legal systems and national traditions, or is there more to them? Do they make law? Do they push certain developments? Do they select between possible interpretations? And finally, in view of the diversity of the interpretative communities, can legal methodology guarantee legal secure outcomes and coherent interpretations? Or does the diversity of actors negatively impact on legal security so that it might even weaken the compliance pull of IHL? And the third hypothesis that we have formulated is concerned with power asymmetries and exclusion. Here we asked our contributors to take a closer look at the role of states from the global south and on violent non-state actors in order to assess how the lawmaking processes deals with asymmetries in actors' power and how it limits political domination and secures participation for all those who are expected to comply with IHL. The underlying concern of our book relates to the overall assessment of these developments. We are concerned that these developments may even reflect that IHL's underlying consensus is fraying, and that we may see indications for a deeper legitimacy crisis of the whole legal regime where actors cannot agree on interpretations of its most fundamental norms or even on its sphere of application, which is certainly a very necessary precondition for talking about the law. To answer these lead questions, the book is designed as a discursive exercise. Each part contains a main chapter or main chapters, which are then commented upon by other experts. So this aims to invite a dialogue between practitioners and academics, general international lawyers and IHL experts, between the global north and the global south, as well as between different disciplines, in particular international lawyers and IR scholars. So the questions of this book are dealt with, through 8 parts. We start with reflections on the rather opaque concept of legitimacy, and then turn to the issue of informal lawmaking and ask why and whether formal means of lawmaking seem to be largely replaced. In this respect, Timothy Meyer, for instance, asks whether non-compliance may contribute to lawmaking in IHL, which he will later present on. The next part is devoted to legal methodology, and in today's event, Jean-Marie Henckaerts will provide insights into his practical experiences and the ICRC's methodology in interpreting IHL. In the book, the following part zooms in on the role of state bodies, above all courts, and manuals, and compares the pros and cons of these 2 types of processes or actors, and it will address, and it addresses related legitimacy concerns. Part 6 then explores further indicators for legitimacy, such as participation and procedural justice, and discusses the possibility for states and armed groups from the global south to influence formal and informal lawmaking. And Hyeran will later provide insights into the role of armed groups. Before concluding, Part 7 deals with the relevant role of human rights advocacy and public opinion in lawmaking, as they are kind of actors external to the law, but maybe particularly indicative of a more fundamental shift of the underlying understandings and consensus of international humanitarian law. So based on the contributions of our authors that have dealt with those research questions, we have worked on some tentative conclusions, and I will now hand over to Jonas to present the main findings that can be derived from our book's content. So Jonas, this is your turn.
Yes, thank you very much. And hello, also good evening from my side. I will directly follow up, but before doing this, I would first of all, of course, like to thank ALMA-IHL for the invitation and this opportunity here to present and discuss the book. And drawing on what Heike has just said, for the remainder of time, I will present to you some of our key findings that can be derived on the books in which we found that the authors considered in answering the questions. And these key findings can be broadly summarized as follows in 3 points. First of all, that underneath IHL's high normative legitimacy, there are competing narrative of IHL's purpose, and this results in diverging agendas within approaches to its interpretation. And secondly, IHL's lawmaking processes that aims to clarify the legal regime are often perceived as lacking legitimacy. And thirdly, states, as the former gatekeepers of international law, are increasingly reluctant to fill the role as primary lawmakers. And the reason for this can especially be seen in light of the plurality of those interpretative communities that we describe in the book. And this in turn creates a legal vacuum. At the outset, I have to note that time, of course, does not allow to consider all the 26 chapters of the book, but I will try to briefly explain some of the reasons for coming to this conclusion. First, on the competing narratives of IHL's purpose and the diverging agendas. Of course, one has to ask, why question international humanitarian law's legitimacy? On the surface, the legal regime's legitimacy is beyond doubt. And even its very purpose evokes an impression of high normative legitimacy, as it protects against and restricts the effects of warfare and aims to reduce suffering and war. This is also why the International Court of Justice, for instance, claims that overriding considerations of humanity lie at the heart of IHL. But still, we find that contestations are increasingly taking place underneath the surface. For pacifists, for instance, IHL may be seen as an instrument enabling or at least perpetuating conflicts as it even creates the impression that there is such a thing as a humane war. And from a humanitarian viewpoint, there's also sometimes a certain unease with the conceptual dialectic underpinning IHL between claims of humanity on the one hand and military necessity. And this agenda motivates the adoption of a more critical stance towards those fundamental foundation underpinnings and brings about the desire to change the law towards a stronger humanization. And especially taking into account the now increasing participation of scholars with a human rights or international criminal law background, for them, IHL may actually appear more permissive than restrictive. But we also find that simultaneously, on the other hand, a counter-narrative to this is produced by mainstream IHL and military lawyers. From this viewpoint, there's an increasing risk that the legal regime and its interpretations lose sight of the right balancing between military necessity on the one hand and considerations of humanity. And those diverging perspectives on the body of IHL lead to a current and ongoing tug of war between different interpretative communities, which is actually threatening IHL's underlying consensus. And this also creates ambivalences in the interpretation of IHL, even for its key norms, and especially in light of the absence of states' engagement with the legal regime. On the one hand, we acknowledge, of course, that IHL is no mere self-regulation of military practitioners. And in this respect, we also find in our authors find that a broadened engagement by different interpretive communities may result in the pluralization and even democratization of the lawmaking, thus enhancing the legitimacy of the regime. And this can even improve IHL's capacity to resolve normative uncertainties and thereby enhancing its determinacy. But to achieve this purpose, these processes must be seen as legitimate by the relevant actors who apply IHL. But we find, however, that instead of the multiplication of relevant actors having led to a strengthening of this legal regime, it contributes to already existing ambiguities. Contestations surrounding the legal structure and values that underpin IHL become now more visible, and particular because of divergent interpretations by actors that formerly only existed outside of the legal regime, such as non-state actors and members of human rights communities, as well as civil society actors, including even the media. And among the main reasons that have been identified within the book why those lawmaking processes appear as illegitimate, our authors identified the following. First of all, non-state armed groups are largely excluded from lawmaking. Within dominant interpretations of IHL, the legal regime scope has expanded in order to oppose obligations on non-state actors. However, non-state armed groups, for instance, have largely been excluded from lawmaking and are even delegitimized by international humanitarian law. And this may result in a lack of shared understanding of the norms' value by those who have to apply them and are bound by IHL's norms, or in any case, a lack of ownership. And according to some of our authors, a more active participation of armed groups, at least indirectly, and a more inclusive lawmaking process can, while not being the only factor or precondition of IHL's legitimacy, enhance the legitimacy. Secondly, many authors highlight the limited inclusion of states of the Global South in the global lawmaking processes. As shown in our chapter, states of the Global South have largely been excluded from lawmaking in IHL's early evolution. This even continues today when especially military powerful states, such as the US, delegitimize the Global South's customary law practices by employing the doctrine of specially affected states. And this gives the impression of IHL or global IHL as a body that has pre-existed and where a periphery can only add to. And as a result, or like as a countermeasure, we often find regional IHL treaties and practices that are perceived of by those states as being better suited to correspond to the realities on the ground, questioning, however, the relevancy of one global IHL. Further, we find that lawmaking by international and national courts and expert bodies, such as manual processes, have a rather ambiguous role. They are often perceived as lawmaking in disguise instead of a mere interpretation or restatement of international humanitarian law. Contributors to our book, for instance, find that manuals do often not inform only the interpretation of the law, but are used instead of the law. And this is especially important as manuals are vastly criticized as making the lege ferenda findings presented as de lege lata. And in doing so, they are often perceived illegitimate. Especially pronouncements by international courts, such as international criminal courts, are often faced with the criticism of not following a uniform methodology. And on the other hand, manual processes are perceived as political actors that lack inclusiveness or representativeness. And outside of all these legal communities, we see a growing influence of norm entrepreneurs in the sphere of IHL with evaluations that are external to IHL. For instance, real-time broadcasting and media coverages critical of states' behavior that actually conforms with dominant interpretations of IHL are indicative of declining support for the moral claims inherent in IHL and are thereby creating a form of cognitive dissonance by decoupling legal standards with other normative assessments within the public sphere. And this perception of current lawmaking processes as lacking legitimacy for some has negative repercussions on the determinacy of IHL. In this environment, we find that states, as the former gatekeepers of international law, are increasingly reluctant to fill their role, especially because of the plurality of interpretive communities, and thereby creating a legal vacuum. On the one hand, one could argue that the current state of the legal regime may serve states' interests, as it allows for some to choose from available interpretations without significantly engaging with the legal regime. On the other side, however, it may also be that the multiplication of lawmaking institutions contributes to states' reluctance to engage in formal lawmaking. We can, for instance, observe that it's unlikely that there is a normative development where an issue had been covered by a manual process, and vice versa, where there had been a new treaty, there has not been a manual process beforehand. And this indicates that states' participation is actually hampered, as it required a great deal of argumentative effort now to deviate from generally accepted interpretations or to engage even in lawmaking, where manuals describe existing norms to be sufficient. And this only becomes more difficult in an environment where external assessments of the law, such as feelings of morality or unjustness, may prevent states from openly expressing their views, which may provide an incentive to rather engage in informal lawmaking to avoid public scrutiny at the cost of legitimacy. An example for the role and influence of such external assessments to the law can, for instance, be exemplified by the process surrounding the Oslo Safe School Declaration, a non-binding document in which states commit to prevent a military use of schools and university. At the outset, some states opposed the document because they argued that it would constrain a military commander's choices beyond what IHL requires. But due to heavy criticism and moral pressure, especially from media, states such as Germany eventually committed to the declaration. But after having said all that and the reluctance of states, we can also notice that there is an exception to the state of affairs, and we can currently observe in the field of cyberspace that states are reclaiming the lead and established even 2 intergovernmental processes that work on the application of international law to cyberspace. And this is also an important development, as in such new areas, as some of our contributors highlight, international expert bodies and manual processes necessarily have to venture into the political rather than the purely legal domain. But still, in light of those findings, we eventually conclude that the legitimacy challenges of the lawmaking processes that are presented in the book signal that IHL's underlying consensus is fraying and thereby revealing a deeper legitimacy crisis. The multiplication of lawmaking force shows that IHL is undergoing a deeper process of norm change, the outcome of which remains still open. And this is especially worrying, as by its nature, IHL has eventually to be applied on the ground, and thereby requiring a high degree of determinacy. And we find that a remedy to this rather ambiguous state of the legal regime could be provided by a more active engagement of states with the legal regime within a more broadly and open and inclusive lawmaking process, which, however, we cannot currently observe. And with this, I want to conclude and thank you for your attention. Yeah, and I'm looking forward to the discussion.
Thank you very much, Heike and Jonas. And now we move forward with the chapters of the book, and we have 3 selected authors, and they're going to present in the order that the chapters appear in the book to maintain some of the organizational method that Heike presented earlier. So we're going to start with Tim Meyer, please.
Great. Well, thank you. Thank you to Heike and Jonas for the opportunity to contribute to this book, and for all of you for attending the talk. So my subject for the book was non-compliance as lawmaking. And when you think of the legitimacy of any lawmaking process in pretty much any area of the law, I think the idea that non-compliance could contribute in a productive way or a way that might be desirable to lawmaking is perhaps one of the central challenges to the legitimacy of any sort of lawmaking process. Non-compliance, violations of the law strike at the very core of the enterprise of lawmaking. To the idea, and this is, I think, especially so today, the idea that a violation of the law might sort of be the beginning of a process of legitimizing and legalizing the very conduct that violated the norms of the international community and that states have approved. That kind of thing strikes at the heart of the idea that international law can really constrain state behavior, and that the normative judgments that have been made and embodied and codified in international treaties and international custom, that they can really restrain state behavior and really have some kind of meaning. At the same time, I think it's undeniable that non-compliance has, over decades and centuries, proven to be a spur to legal change. It is clearly the case that we can all identify examples, particularly in the customary international law area, but also in the treaty space, in which violations by states that are often deliberate and are designed to be public have been used as a vehicle to essentially what I'm going to describe as renegotiate the understandings of what counts as compliance with international rules. And this presents us with, I think, a very, very difficult challenge, which is how do we start to think about distinguishing non-compliance that is just the ordinary violation of the law from non-compliance that is designed to be jurisgenerative, if you will, that's designed to generate new law, that's designed to perform a lawmaking function. So we can ask a descriptive question about whether or not lawmaking is or can be, or how it is undertaken through non-compliance. And then we can ask a second normative question, which is about when is it likely to be desirable, or when is it likely to be in the interest of the global community, states as a whole, or maybe only individual states, to pursue non-compliance through, to pursue lawmaking through non-compliance. So in just the few minutes we have here, I just want to discuss a little bit of the conceptual challenge. I want to say a little bit about the way in which we might have a positive theory or a descriptive theory of when non-compliance is likely to be successful as a form of lawmaking. And I'll just very briefly say something normatively, but mostly defer that to the Q&A. So first of all, obviously, it's often the case that non-compliance is just non-compliance. It doesn't really spur any change to the law. States behave in ways that they themselves, although they might not admit it in the context of their own behavior, they are, in a general sense, happy to condemn it as being inconsistent, and they're not using their own behavior, their own non-compliant behavior, as a basis for a claim about how the law should change. The sort of the best example of this from the last several decades is probably the use of torture. So unfortunately, so many states have engaged in conduct that we might think of as being torture. The United States arguably engaged in this conduct during the Bush administration, particularly as regards to this is the program of enhanced interrogation, and particularly the practice of waterboarding the Bush administration used during the first decade of this century. There's not really a serious claim that the fact that that kind of conduct was going on really changed the view of countries that torture is inconsistent with international law. Those were just violations. They were just ordinary violations. On the other hand, it is pretty easy to think of examples in which violations of the law have in fact been both designed to and have successfully changed the law. And so just a couple of examples that will be familiar, I think, to many of you who work in, at least in general international law, but probably the best example of this is the territorial sea. So the territorial sea is the amount of essentially water off of a nation's coast that fits within its national jurisdiction. It used to be 3 miles, the proverbial cannon shot. And through a series of violations of that 3-mile norm and states unilaterally claiming extensions of the territorial sea, it eventually settled at a 12-mile territorial sea. That's a customary international law example, though later codified. We also have examples of treaties where states' expectation as to what counts as compliance with a treaty provision can essentially be recalibrated via non-compliance. And so the example I often think of here has to do with the Reagan administration's use of the Strategic Defense Initiative. This is Reagan's sort of Star Wars program, which was arguably, somewhere between arguably and clearly inconsistent with the Anti-Ballistic Missile Treaty. And yet, essentially, the Soviet Union ultimately, although registering an objection, ultimately agrees that this is going to be consistent with the treaty. And then, for a number of years thereafter, both parties proceed on that basis. So we can see that non-compliance has this jurisgenerative function, that it can shift either claims about what customary international law entails or what's permitted under certain kinds of treaty provisions. Now, it's important to note that if we think of non-compliance as cheating and non-compliance as lawmaking, they have, and we think of these as sort of ideal types, they have entirely different objectives. Non-compliance as cheating is designed to get the cheating state, the violating state, an immediate benefit from its behavior. Non-compliance that is designed to change the law is not designed, or is not necessarily designed, to immediately benefit the violating country. In fact, as I'm about to explain, the violating state in that situation is actually going to embrace the idea that it's probably going to be sanctioned for its conduct. And what it's really looking forward to are benefits that come not just from its own behavior, but from changes in the behavior of other states. It is the future change in behavior of other states that is going to create value for a violating state that's trying to change the law through non-compliance. Okay, and that's a very different calculus that state goes through, which has implications for both when non-compliance is likely to be successful as a lawmaking technique, and for how we might think about how you would deter non-compliance as a form of lawmaking. So let me just say a little bit about non-compliance as a sort of a descriptive matter as to when we might expect it to be successful and how states are likely to approach it. And in the chapter, I lay out 4 factors that get at the role, or when it is likely to be the case that states are going to be successful or more likely to be successful using non-compliance as a form of lawmaking. And those 4 factors are the violation has to be public. There has to be a credible threat that the state is going to continue the violation into the future. The content of the violating state's proposed norm has to be acceptable to at least some range of other states. And it has to be the case that the violating state prefers the costs of violation to the costs of lawmaking through more traditional fora, such as negotiation in the context of a multilateral treaty. So let me just say a little bit about each of those 4 factors. So first of all, one of the absolutely most significant distinctions between non-compliance as lawmaking versus non-compliance as cheating is the public nature of the violation. It does not work to violate the law secretly if your goal is to change the way other states view the law. So it is often the case that you may try to disguise your misconduct. You may try to disguise your violation of IHL. If you try to disguise your violation, it is not going to have any sort of lawmaking effect, because if you're successful, no one will know about it. And if you're unsuccessful, you're in the posture of actually defending, potentially having to defend it as being legal, or being caught out in an indefensible violation and being left with no real legal claim. So it's going to be important for a state that's trying to use non-compliance as a lawmaking technique to actually almost announce what it's done and be prepared to embrace the legality of it in a forward-looking way, as opposed to sort of being left back on its heels when it's been caught out by another state essentially detecting a violation and denouncing it. Okay, so that public facing nature of non-compliance as lawmaking is a major difference from just sort of cheating, where there's a major incentive there to try to conceal your violations in order to avoid being sanctioned, right? If you're a cheater, you want to conceal your violations because you avoid sanction and you get the benefit of your behavior. If you're trying to change the law, you have to have a public justification for your behavior, and therefore your behavior has to be public. Otherwise, there's no hope of changing other states' behavior in order to get them to comply with your proposed norm. Quickly, just because I know we're a little short on time here, let me run through the others, and they're a little bit more self-explanatory. The first is that it has to be the case that you intend to behave this way into the future, or at least that other states think it's likely that you will behave this way into the future. So you have to have a credible threat that you're going to continue the violation. So Isabel Hull has a lovely book on the laws of war in the 19th century leading up to the First World War, and she's got some great examples of this. So one of the changes that came about through the wars leading up to the First World War had to do with the sinking of neutral vessels. And in the middle of the 19th century, a handful of countries changed their naval manuals to allow the sinking of neutral vessels, but they didn't act on it. And so the laws of war basically didn't change in response. They had made a claim essentially that this was lawful conduct, but they hadn't really, if you will, sort of put their shoulder to it. They hadn't demonstrated that they were prepared to act on the basis of that rule. And therefore, this sort of proposed norm was inherently not credible to other countries. Later, during the Russo-Japanese War, you start to see conduct that is consistent with this norm. You start to see the sinking of these neutral vessels. And all of a sudden, you start to see a reconsideration of the norm, because now the violator's threat that we are going to behave consistently with this norm becomes more credible. And this ultimately triggers a renegotiation in which it's accepted that under some limited circumstances, it might be acceptable to sink these neutral vessels. The second the third and related norm here has to do with the acceptability of the proposed rule to other countries. Even if it's credible that you're going to just keep violating the law into the future, if other states find your proposed change totally unacceptable, they are simply going to view you as a violator. You will have essentially have withdrawn from the international rules, but you will not be able to move those states to join you in essentially shifting expectations about what counts as compliance, right? So there has to be some acceptable content. And again, we get some examples from World War I here. The British blockade of Germany at the time was, there was some concern, particularly as applied to neutrals. There was some concern that the specific conduct in which the British were engaging might not be consistent with the laws of war. The neutrals certainly felt that way, and actually even France was concerned about this. After the war, though, in the San Remo Manual, nations essentially ratified the British conduct as a acceptable modern adaptation of the maritime rules of conflict. The norm was, in other words, successful. I'll just end briefly on the last point, and I want to be mindful of time here. So the last point is just that multilateral lawmaking processes, as we heard Heike and Jonas say, they've become, and this is true across all of international law, they've become so slow, so bogged down, and potentially so unproductive in terms of their ability to achieve consensus-driven outcomes that they have become unattractive or increasingly unattractive as venues. And you see states that are increasingly willing to violate the law as a spur to renegotiation and as an alternative to trying to work, or at least as a complement to working through multilateral processes. there's a sense that that the costs of non-compliance that a violator will incur, even when behaving in a way that's designed to spur lawmaking, those costs may be lower than the cost of delay and potentially the cost of failed multilateral lawmaking through really protracted negotiations that can take years and years and years. So those are the four factors. Obviously, and I'll just say, and I'll end on just a brief comment about normative implications here. It is obviously the case that there are going to be situations in which, and many situations in which non-compliance as lawmaking is going to be undesirable because it's going to be a violator simply trying to create a rule that works in its benefit but may not work in the benefit of others. However, what I want to suggest in the chapter is we can overstate the extent to which non-compliance as lawmaking is likely to be unproductive, that there are going to be situations, and perhaps many situations, in which non-compliance can break a logjam in multilateral lawmaking. And in those sorts of situations, non-compliance as lawmaking actually could be a technique that creates sort of general welfare benefits for nations as a whole. And the challenge is to say more about and to figure out when non-compliance as lawmaking is likely to be in the general interest, when it's likely to promote general welfare, and when it's simply going to be redistributing to the violator. And then to think about rules that deter non-compliance, especially in those situations in which we would expect that non-compliance as lawmaking is only shifting the legal norms in favor of the violator without any offsetting benefit for other countries. So I'll stop there, and I look forward to the discussion.
Thank you very much, Tim. Now we move forward to Jean-Marie.
Okay, can you hear me? All right. Thank you. Thank you very much, Ido, for giving me the floor. It's my pleasure as well, an honor to participate in this book launch. And it has also been a pleasure, I should say, to participate with my co-author and colleague, Alvina Potelet, in this book project. So our chapter reflects the experience we have gained in updating the commentaries on the Geneva Conventions. And in particular, at the time when we wrote the chapter, it was our experience with the very first commentary, the commentary on the first Geneva Convention. So our chapter is about treaty interpretation, but it fits nevertheless within the framework of the book, which is about lawmaking, because interestingly, in the introduction, Professor Krieger and Mr. Püschmann referred to a definition of lawmaking offered by Sandesh Sivakumaran, who many of us know, where he defines lawmaking in this area as the whole spectrum of lawmaking and shaping activities, including the interpretation and application of international law, the identification of custom, and the development of the law and the adoption of soft law instruments and manuals. So that's the whole framework. And in the various chapters of the book, of course, several people speak about this. But so under this definition, then interpretation also falls within lawmaking, even though it is not making the law as such, but interpreting the law that exists. So as you may know, the original commentaries on the Geneva Conventions were published in the 1950s. And in recent decades, it became clear that they were both outdated because of the passage of time and incomplete because they did not discuss issues that arose in practice. And therefore, the ICRC, the International Committee of the Red Cross, initiated a process to update these commentaries. The original commentaries were based primarily on the preparatory work to which several of its authors participated. For example, Jean Pictet, René Jean Wilhelm was, for example, in the committee that developed the Third Geneva Convention. So the authors were actually there when the conventions were being discussed and negotiated. And also on prior practice, so practice from before the adoption of the conventions, most importantly the Second World War, but also the Spanish and Greek civil wars, which had informed the negotiations. So you had prior practice, then you had negotiations, and then you had commentaries. And of course, the current exercises about the conventions, subsequent practice, and commentaries that follow thereafter. and the preparatory work is far away. It's even before the adoption of the treaties. So we take a different approach and different outlook, so to speak. Also to say that in our current work on updating the commentaries, we apply the rules on treaty interpretation that we are all familiar with, set out in Articles 31 to 33 of the Vienna Convention on the Law of Treaties, or VCLT. Those rules were not available or not as such codified at the time the original commentaries were drafted. So if you look at the commentary, I would say from before 1969 and the Vienna Convention, you might have a slightly different vocabulary or approach as you would find in a commentary that is published afterwards and that applies the framework of the VCLT. So today, any treaty interpretation should be based on these rules, as they generally are seen to reflect customary international law. Because formally, the Vienna Convention only applies to treaties adopted after 1969, but as customary rules, they are also applicable to treaties adopted before. So in our chapter, we briefly discuss each of the elements in the menu of the VCLT method. I call it a menu, a full course menu, because no element of this menu may be skipped. It's not a pick and choose, because often we see debates about a literal interpretation, for example, and teleological interpretation, but actually the VCLT does not favor one or the other, but says that you have to look at all the elements in a comprehensive manner. So it is one exercise, one interpretation. And those elements are, and I'm just going to name them, I'm not going to actually go into any detail here, but they are discussed to some extent in our chapter. So that the interpretation has to take place in good faith and based on the ordinary meaning of the text. So that is the literal interpretation that I refer to, but also in light of the object and purpose of the treaty. That refers often to it's referred to as the teleological interpretation. And as I said, the VCLT does not favor one or the other, but actually requires a mix of both. And then it refers to subsequent developments, to which I shall say a bit more later on and give some examples. So these include both subsequent practice and subsequent developments in law. So we can say developments in law and practice, basically. So subsequent practice, we have recently, with the work of the International Law Commission, gotten the clarification from the International Law Commission, at least, that the subsequent practice under Article 31 refers to practice that established the agreement of all parties to a treaty. Now, for a bilateral treaty or a treaty between 3 or 4 states, this is possible to achieve, but it's very difficult to achieve, or like for treaties that have universal ratification, like the Geneva Conventions, with 196 states parties, to show that a certain subsequent practice really establishes the agreement of all the parties to the treaty. There may be cases where silence can be used to prove this existence, but it's not obvious that this silence evidences the agreements of all parties. But the ILC has also said that subsequent practice not meeting this threshold of establishing the agreement of all parties can still be used as a supplementary means of interpretation under Article 32. So that's clearly a recognition of what actually I think many commentators and commentaries and also scholars and authors have actually been doing when interpreting treaties. They refer to bits and pieces of examples of state practice and to some manuals and to some legislation and some case law, basically gathering everything that one can possibly find that sheds light on how this particular rule has been applied and interpreted. So this, the ILC calls subsequent practice in the broad sense. And then the second element is developments in international law. So other relevant rules of international law, which of course in the area of IHL, there are many since 1949. And we also have to take these into account to make sure that the Geneva Conventions are interpreted as part of the overall framework of international law. And then quickly, the supplementary means, they include the preparatory work, which, as I said before, was one of the main points of the original commentaries, and which clearly now are only a supplementary means of interpretation. Subsequent practice in the broad sense, a supplementary means as well, but indeed a very important one, because there have been many subsequent developments and subsequent practice in the application of the Geneva Conventions. And we also develop in this chapter references as a supplementary means of interpretation, namely international judicial decisions and publications of the most qualified publicists from the various nations, because both of these are mentioned in Article 38 of the ICJ statute as supplementary means to identify rules of international law. So we consider that they should also be seen as supplementary means to interpret international law. They are not specifically mentioned in Article 32, but Article 32 is open-ended because it mentions the preparatory work and also the conditions of the circumstances, excuse me, of the adoption of the treaty as examples of supplementary means. And it does not mention international judicial decisions, for example. And this again reflects what most authors, I would say, are doing when they write commentaries, and what interpretation, even by courts, is looking at these elements of interpretation. So as a result of these rules on interpretation that exist in the VCLT, we look more at subsequent practice, as I said, i.e. the practice by states after the adoption of the treaties. And there's a lot of subsequent practice. As treaties age, the practice in their application increases, unless it's a very unsuccessful treaty, but it's certainly the case for the universally ratified Geneva Conventions. Mostly subsequent practice in the broad sense, as I said. The amount of developments in law and practice is also shown by the volume of the updated commentaries. I mean, I'm not saying this, to look at how big the books have become, but the books have become bigger than the initial commentaries simply because there are more issues to discuss because of developments in law and practice. And on each issue, there is more to say because we have more references, we have case law, we have more manuals, and so on. We have more academic commentary. So that is why the commentary has grown. I mean, it really physically reflects that reality. And we naturally focus less on the preparatory work as more details have been provided over time by the other elements of interpretation. So I actually forgot to start my clock, so you can indicate to me maybe how much time I have left.
About 5 minutes.
5, okay. The VCLT, I had it already here, and then of course I forgot to press start. So the VCLT framework clearly endorses an approach that allows treaties to evolve over time by taking into account subsequent developments, both in the form of practice and in the form of other relevant rules. So developments in law and practice, as I have said. Thus, international law is not static and can evolve over time under the influence of state practice and under the influence of other rules of international law. And so in our part, Emily Crawford's chapter gives an example of how the meaning of non-international armed conflict has evolved from what was understood during the negotiations by many delegations as being a high-level threshold to what the definition is today as put forward by the ICTY and endorsed inter alia in the ICC statute, namely a lower threshold, not requiring territorial control, for example. So this is an example of the type of evolution the VCLT allows. And in our own chapter, we highlight the example of the obligation to apply the convention with the cooperation of a protecting power, a practice that has not taken place since the Falklands-Malvinas conflict in 1982, exactly 40 years ago. So as a result, we consider that Article 8 of the Convention, Common Article 8, that says that the Convention shall be applied with the cooperation and under the scrutiny of the protecting powers, that has actually become optional, namely a may. So Tim Meyer would say that is an example of a violation changing the law because they did not apply after 1982 the Convention with the cooperation of protecting powers, and other states did not object. And hence, the interpretation of the rule changed. Another example would be Article 38(2) of the Convention in relation to the emblems, but I won't go into that for lack of time. And so one can question whether such an evolution is not actually a modification of the treaty, And I would say no, because there are specific procedures to modify a treaty foreseen in the VCLT. But what happens here in these examples of protecting power and the emblem is that the interpretation of the provision has changed over time. The change can be rather dramatic, but we still remain within the bounds of the treaty and within an exercise of interpretation. That's also at least how the ILC presents its work on subsequent practice. Another case and another example is where the interpretation involves identifying a rule in a text which is not explicitly stated. For example, the updated commentary on Common Article 3 includes a section on sexual violence, although the article does not specifically mention this type of violence. So in so doing, the commentary does not create new law, but reflects developments in law and practice, as well as a contemporary recognition of factual contexts that were obscured for various reasons at the time the conventions were concluded. So sexual violence is now universally recognized as conduct that constitutes violence to life and person, outrages upon personal dignity, acts that are explicitly prohibited by Common Article 3. So similarly, although Common Article 3 does not mention rape, international and national case law has nonetheless recognized rape as an act of torture. So there's a whole section on this, and one might question, or is this lawmaking or is this interpretation? But again, I would say it falls within the realm of interpretation, and it is the proper role of a commentary to address this. Now, briefly, so this is an overview of the technical aspects of the chapter, which was developed in reaction to Emily Crawford's article, actually, about the change of the interpretation of non-international armed conflicts in Common Article 3 as an example of how subsequent developments have this influence. Now, in terms of legitimacy, which I'm questioned by our discussion and Heike's introduction, so I think this can be examined for the whole range of actors that carry out interpretation, including states, courts, organizations, NGOs, academics. As far as the ICRC is concerned, I believe the legitimacy of our work rests on maybe three pillars. First, a formal one, which is the statutes of the Red Cross and Red Crescent movement, adopted by all states parties to the Geneva Conventions, which set out the role of the ICRC and which includes to work for the faithful application of IHL. So this requires the ICRC to interpret the Geneva Conventions. We have received this role and mandate, so to speak. And secondly, to work for the understanding and dissemination of knowledge of IHL. So the commentaries are one of the products or publications with the aim to provide anyone working in IHL access to all elements of interpretation. The other pillar, second one, is one maybe that you mentioned as methodology, namely applying in good faith and to the best of our ability the Vclt methodology. We try to achieve this through in-depth research and a rigorous review process. This means that we do our utmost best to look at all the elements in the Vclt in good faith, starting with the ordinary meaning of the terms and followed by the other elements of the Vclt menu. So this is legal methodology to support legitimacy, basically to provide high quality commentary. Do we have a hidden agenda? Because you mentioned this term at the beginning, Heike. Well, no, we seek really to clarify to the greatest extent the commentaries, and we have also proven this in the introductions of the commentaries to clearly define the object and purpose, and more clearly so in the Third Geneva Convention, as a balance between considerations of humanity and military necessity, because of course some might say that the ICRC will err rather on the side of humanity, but we also have to take into account, of course, the military necessity element in order to be legitimate and to be seen legitimate by one of the constituencies using the Geneva Conventions, applying them and using the commentary, which is the military. And a final pillar, and this is my last point, is the connection between these two, actually, between the formal role in the statutes and the list of elements in the Vclt menu, which includes subsequent practice. And that is the ICRC's practical work on the ground, observing the application of the Geneva Conventions on a daily basis. This was very clear more recently in our work on the Third Geneva Convention, where we were able to look at the reports of ICRC visits to POW camps that reveal practice in the form of examples of compliance, best practices, but also obstacles and violations. So this final pillar, this third pillar, is to say that the ICRC is well placed to undertake this work by its presence on the ground. However, ultimately, of course, the proof of the pudding is in the eating, and it will be through the use of the commentaries by lawyers, by courts, by organizations and academics that they will have, that we will have to prove that they are seen as a legitimate exercise and that they gain a following. Thank you.
Thank you very much, Jean-Marie. And now we move forward with Hyeran Joe. Please, the floor is yours.
Thank you so much to Ido for holding this book launch event. I'm going to talk about chapter 21, and the title is Lawmaking Participation by Non-State Armed Groups, the Prerequisite of Law's Legitimacy. And this is the title given by Professor Krieger. Actually, it wasn't not my invention. And I think it was very clever to use the word participation instead of lawmaking directly. And the question about whether it's prerequisite, whether it's necessary to really establish IHL's legitimacy, I think it's an important question to answer now that we have so many non-state armed groups and actors, associated actors, violating international humanitarian law. And before I give my answer, I want to start with my caveat that I'm not a legal scholar. I'm trained as political scientist, so I usually work with data, although I have learned a lot over time about international law. And to this question of whether lawmaking participation by non-state armed actors and groups, whether it's prerequisite for international humanitarian law's legitimacy, my answer is that it might not be a prerequisite, it might not be necessary to have it, but it could be helpful to have lawmaking participation by non-state armed actors. And I give approximately 3 reasons. The first reason is that non-state armed actors are already doing it, are already participating in lawmaking. And if you compare Geneva Convention negotiation back in 1949, about 10 non-state armed actors, including ANC from South Africa, participated as observers. So they had voices, so they were there physically, but they didn't have any votes. So that was 1949. And fast forward in 2015, if you look at Bogota, President Santos, former President Santos, and Timoshenko from FARC negotiated this peace deal, which included international humanitarian clauses. And if you think about these 2 contrasting pictures, lawmaking then and lawmaking now are very different in terms of non-state armed groups participation. And even without this kind of direct participation, some non-state armed actors are already utilizing and partaking in international legal processes. And one example is Front Polisario claiming its self-determination rights at the European Court of Justice. And if you look at the patterns of non-state armed groups participating, here is the collection of the Geneva Call, humanitarian commitments, international humanitarian commitments of non-state armed groups. And you see a lot of international code of conduct, unilateral declaration, bilateral agreements through ceasefire. Professor Krieger mentioned it already. And all these options are available for non-state armed actors. So of course, there's questions of plurality of interpretation, as Jonas mentioned, but they are already participating in these activities in various ways and in a very, very decentralized way. Second reason I think lawmaking participation by armed groups is not necessarily prerequisite, but could be helpful, is the legitimacy reasons. So they are heavy users of these international humanitarian laws. Some are violators, some are trying to appeal to international community. They are abiding by international humanitarian law. So sometimes ownership could be helpful, and I see some trajectory of some non-state actors changing their behavior over time by changing internal code of conduct or interacting with international community to change their behavior. So in terms of boosting the law's ownership and buy-in and increasing IHL's legitimacy might be helpful for some of the groups. And the assumption here is that these non-state armed actors come in various stripes. It's not all red or all blue. They come in various stripes in terms of their aims, their behaviors toward law, behaviors toward international humanitarian law in particular. So this brings the question of where does international humanitarian law in particular, law's legitimacy come from? And law's legitimacy is conditioned by many factors, including state compliance and civil society support. And if we consider international law relevant to general public, then public support. So other factors might exist for boosting international humanitarian law's legitimacy. So if that's the case, then the participation in lawmaking by non-state armed actors might not be that critical. So I think it might not be a prerequisite, but other factors might weigh in, sometimes interactively, sometimes more heavily than the participation by non-state armed actors. The third reason is more practical, that the participation in lawmaking by non-state armed actors are blocked in many cases because we have states as main actors and lawmakers in public and international law. So if we take state-centric view, and if we take the practice of states working as gatekeepers in a lot of humanitarian access and blocking access to like Myanmar and other some of the authoritarian regimes, blocking international humanitarian law promoters from interacting with non-state actors, one might think that the participation in lawmaking by non-state armed groups is not really practical idea in light of these practices of some authoritarian states. So I conclude with main observations about problems and solutions. And non-state armed actors are now prime violators of many international humanitarian norms. And I put three graphs. Actually, one is map, and the first graph is about civilian killing trend from 1990 to 2020. And you see the red now dominates, and the red is the violation, the civilian killing trend of non-state armed actors, and the blue one is state-based violence, which is civilian killing. And we see that non-state armed actors are now primary violators, and the picture is a little bit different from before 1990. And if we look at the child soldier issue, about 10 states are listed on the UN's list of shame in terms of violence against children, but then 60 non-state actors are on the UN shame list. And the third graph is sexual violence, and Jean-Marie mentioned the legal aspect of sexual violence, and we political scientists collect data of non-state actors committing these sexual violence and wartime rape, especially. And if you look at this trend as well, the violation committed by militias and non-state armed actors are surpassing state army or national army violations. So now that we have these violators, the question I think for us is maybe to some non-state armed groups that are willing and could really change behaviors after the participation of lawmaking in international humanitarian law, maybe there might be some chance that we could shift the equilibrium from non-violence, non-compliance to compliance. So I'm developing this theory of tailoring to the target. So depending on the target, depending on the characteristics of non-state armed groups, maybe the solution of legal lawmaking participation might be different. And also in terms of timing, the timing of peace talks might be prime time to engage these actors for lawmaking participation. So that is kind of what's going on after writing this chapter. So thank you.
Thank you very much. Okay, so now we have some time for Q&A. If anyone from the audience has a question, please you either use the raise hand feature or write in the chat, and we'll give you the floor to ask a question or make a comment. I do have one question to start things up, and my question is for Tim. When I look at the structure of the four tests for change, it seems that it gives an inherent advantage to strong states, the ones that are willing to pay the price of a violation and do it publicly. And I think we've seen one of those in the recent days, for example, but not necessarily that example alone. What do you think about that inherent advantage?
So I think that's absolutely right. You know, those four factors are designed not to be normative. It's not necessarily the way we would want the system to be set up. They're meant to be descriptive as to when this is likely to be successful. And I think there's no doubt that large, powerful states are going to be able to more effectively exploit non-compliance as a lawmaking technique, both because they're more effectively able to bear the costs of any sanctions, and also because they're just less likely to face the sanctions in the first place. They have tools essentially to diffuse those. I do think that in some areas of the law in particular, and IHL may be one of these, there might be reasons, and it depends on what specific rule you're talking about, but there may be reasons to think that it's better to coordinate, it's better for everybody to coordinate on what large states are likely to do. Because to the extent that just coordinating is the main value, knowing what the rule is, to the extent that is where we get the value from cooperation, then having large states have a little bit of flexibility to sort of update those rules, I think is important. And I should say, Jean-Marie was I think very careful to distinguish between interpreting and interpretation and lawmaking. And so wearing my lawyer hat, I completely agree with his characterization of those things. I do think that we can, if we step into a political science realm, or a realm in which we are thinking more about, we're less attached to legal categories, then we can recognize that interpretation performs a lawmaking-like function to the extent that it legitimates or doesn't certain kinds of conduct. And again, to your question, clearly more powerful states are going to be able to make use of those techniques more effectively.
I see that we have a question in the chat from Itai Epstein. Itai, would you like to use your audio and camera and ask your question, or just read it from the, or just read it? Okay. So Tim and Jean-Marie, would you consider the non-implementation of general Geneva Convention Article 1, Common Article of Geneva 1, external and positive obligation to ensure respect, an example of lawmaking by non-compliance? Let's start with Jean-Marie.
Yes, so Common Article 1 is also an interesting example on interpretation. I had even wanted to mention it, but there was no time. But so for me, no, it's not an example of ensuring respect, an example of lawmaking by non-compliance, because we, at least in the commentary, we interpret this as meaning that states do have an external obligation, external and positive, to ensure respect. We do recognize that there's some diverging views, but what I think is particular about this interpretation and state practice, because people will say, where's the practice showing that this is really a legal obligation and that states do this? Well, we do have a lot of references supporting this interpretation, and we also know that there's a lot of hidden practice. So this is maybe a problem in treaty interpretation, is also that not everything meets the eye, because there's a lot of negotiation, discussion going on, in particular in international organizations, to make sure that states respect their obligations under IHL. And that's why Common Article 1 was then supplemented in Additional Protocol 1 by Article 89, in my opinion, which goes a step further and specifically refers to cooperating with the United Nations in the framework of the UN in case of serious violations of IHL. So I think it's an example of this, and where I wanted to mention it also was in relation to how the understanding, because some of the people who do not agree with our interpretation also refer back to some of the statements in the negotiations. And there too, you can refer to statements, but as we know, the preparatory work is not, the ultimate arbiter anymore. This is only a supplementary means of interpretation. But again, if a few states say something about the meaning of this article, but all the other states say nothing, that also shows, in my opinion, that the interpretation that some want there to be, doesn't stand. Just give me 30 seconds to explain. So Common Article 1 says respect and ensure respect, but it doesn't say by whom. So if states really were so weary that this should only apply to their own troops and their own population, they could have put it in Common Article 1. And if two states mentioned it, raised it in the negotiations, then why didn't they put it? So the other 60 participants clearly didn't think that it was so limited. But maybe they didn't say that, but they also didn't put the language in Common Article 1 to clearly delimit the scope as being only applicable to own troops and own territory or own population. So now it's open-ended, and the way it's been applied and interpreted is that it applies externally. So for me, that's the only explanation that in good faith you can achieve on the basis of the Vienna Convention on the Law of Treaties. And this is based on state practice, which is out there, and there is a lot of practice. There is also violation, yes, it's not always complied with, but there is also a lot of compliance with this Common Article 1. Thank you.
I would just add very briefly. So you know, I think we can think of non-compliance as cheating lawmaking. We can think of that as sort of ideal types, and it's often easiest to see and think of examples and to sort of see how it works if you think about clear violations that then become adopted as norms. But we all know, I think, in the real world, oftentimes, as Jean-Marie was just talking about, there's going to be open textured obligations where the answer is not clear and states may have diverging views. And that's going to be a situation in which you're likely to have a similar kind of process to the one I described unfold, where you may have conduct by states that some states feel is inconsistent with an obligation, other states feel is consistent, and you see a similar sort of struggle play out. But to the extent that you have, I think the expression Jean-Marie just used was sort of hidden practice. Hidden practice is still state practice for legal purposes of interpreting, but hidden practice is not going to be effective at shifting expectations if no one knows about it.
Okay, I think we're about to run out of time. I think I want to thank all the participants for a very, very interesting discussion. I'm actually more interested now to read the book even more than I was before, especially now that I got some brief introduction to the book. And we even have the the show off of the title. So I want to thank again Heike, Jonas, Tim, Jean-Marie, and Hyeran for your participation in the event. I want to send a great gratitude to Karolina Grimberg-Goliechov, who coordinated that event and unfortunately couldn't be here with us tonight. And I invite you to follow our future events. We're going to have hopefully a book launch once a month, every month. We already have the next couple of events planned. We're going to announce them soon. And for that, you should either subscribe to our mailing list or our Twitter account, Facebook account. We are everywhere and going to publish our events everywhere. Also, our website is very useful. And this event was, of course, recorded and live streamed, and it's going to be uploaded to our YouTube channel, in which you can also see all of our previous book launches, book launch events. And if you're watching it on YouTube, subscribe. It's right here. So thank you very much. Have a good night and see you in the next event. Thank you.